Yes, so that's section 35. Who may institute proceedings? A decree for nullity of marriage shall be made upon the petition A of the parties.
Shall not.
Decree of nullity of marriage shall not be made upon the petition A of the parties suffering from the incapacity,
which I love so much,
to consummate the marriage on the ground that the marriage is voidable by virtue of section 5 sub 1A of this act, unless that party was not aware of the existence of the incapacity at the time of the marriage.
But then doesn't this work hardship on the person? Like, let's say for instance now.
First of all, explain the law before you now say your personal reservations. So what does that section
relate? The law is saying that if, for instance, a petitioner is the one that is incapable of consummating the marriage, they can't be the one to file for the petition or the solution. That's not what I'm saying.
It means that if you, for instance, you know or you knew that this person smokes before you got married.
This circumstance, inability to consummate.
Okay, yes, you know that man cannot perform in bed, and maybe you told you that he's having erectile dysfunction or whatever it is.
You are tested, you saw that it is not working before you now got married.
Before you now enter, you cannot come and say that I want to file for a dissolution because of that same reason.
Because of that ground. Or for a nullity.
No, for a nullity. But I think for a dissolution it will fly.
No, when you knew.
When you know
for a dissolution
it will fly.
Because you are saying for this ground
I cannot continue.
You can't continue. But to say that the marriage was a nullity
because of that fact.
That you were aware of, it will not fly.
Because you were aware that you could not consummate the marriage, and you continued in the marriage. Because it can be a nullity because he could not consummate and you were not aware.
He did not tell you he's doing a pastor, let us marry before.
And you remember what we discussed about inability to consummate. Inability to consummate is not somebody that cannot have sex for 10 hours. It is a person that cannot penetrate. That is, his penis cannot come up to enter. But Jay, right? That was what we said now. We said that inability to consummate is that he cannot access the vagina, or that a woman's vagina cannot be accessed.
A 2 minutes man.
A 2 minutes man is not an inability to consummate. Especially when you are aware before the marriage, it does not make the marriage a nullity. So if you bring such a petition, it can be dismissed.
But can you bring a petition for dissolution of marriage under the 2 minutes factor?
You cannot.
When we review this law now,
you're not capable of. You did. It's not. It's a you're not capable of staying.
We said that since the marriage was when I believe such a way that the petitioner cannot reasonably. Respondent has decided that the parties have lived apart.
Unless you can prove that the reason why that thing is like that is because he's probably abusing drugs or alcoholism, then that would be a ground.
I don't think you can divorce because of it.
You cannot divorce for 2 minutes, I mean.
It's as a result of your own expertise. I think 2 minutes is not enough now.
Which one is expertise?
Because if that's your first experience, you think it's normal.
Because the law in section 16 actually provided. Let's look at this critically. It's a good question. The question is whether the fact that somebody is a 2 minutes man can be a ground for dissolution of marriage. Now, the only circumstance that would ordinarily fall into is section 15 sub 2c. That says that the marriage since the respondent has behaved in such a way that the petitioner cannot reasonably be expected to leave. Because apart from that, all the other ones does not fall into. The first one is that the respondent has willfully and persistently refused to consummate. That means the person refused to consummate. Not that the person is unable to consummate for 2 hours. Now, that section 2 sub c is provided under section 16, which says that since the marriage, the person has committed rape, since the marriage, the person has been a drunkard or consequently intoxicated, suffered convictions from crimes, and has been sentenced to imprisonment for at least 3 years, attempted murder of the petitioner, inflicted grievous bodily harm, and then has been separated and refused to. The court directed, they were separated, the court directed to come together, the person refused to come back. The person is of unsound mind. And then that unsound mind must show that the person has been kept in an environment where people that are mad are kept for at least 6 years. And then that
6 years.
yes,
Not too long.
we discussed that last time. And then for a period of 7 years, immediately the date of the petition, the other party to the marriage was naturally absent. So there is no provision that relates to a 2 minutes man.
That's what I'm saying.
It was safe.
So, however, if your 2 minutes, if you are not convenient with 2 minutes, something would have led to a separation that would have kept people apart for a period of. A woman can say, I can't deal with it, and she leaves
for 2 years.
for 2 years.
That's when it will now work.
Then she can now file, or he can now file.
If 2 minutes is actually a problem, why you stay for 2 years?
No, that 2 years now, you win now. You have separated yourself.
Yes.
You can have one person to die.
The thing is, if 2 minutes is your problem, I don't think that person that you want to leave a marriage because of 2 minutes. You cannot stay 2 years.
But the law cannot even release you. That's the problem. We discussed it last time now. You are you are still married now. The law now is saying that you can only remove yourself from that marriage by a decree of the court. And it's at the discretion of the court, subject to the provisions of this law. So you cannot force yourself out of a marriage. You are married, you will be married, you stay married.
That's why we should learn from Kim Kardashian.
What happened to Kim Kardashian?
Kim Kardashian was married for 72 hours.
72 hours. My sister, this is our act. If you marry for 48 hours, so far as within those 48 hours, you entered a marriage in the marriage registry, registered under the act, you cannot leave that marriage.
That's what I'm saying, that it works a lot of hardship. The law is old.
It's not old.
No, but no, there are circumstances under which even within 72 hours to fly.
That is when it is a nullity or it was void.
No, not that. For example, like this one, incapable of consummating. No, not consummating. No, 72 hours cannot decide that. Now, when they say in now behaving in a manner that the petitioner cannot reasonably believe, you understand, be expected or reasonably be expected to stay with the person. For example, within 24 hours, you have chased the person out with knife. The person had to run out. That can form a
basis. That is attempt to kill the person. Okay, that was one of the reasons.
Yes, that one now can fly. But so it's an extreme case.
So since the marriage within a period of 1 year immediately preceding date of petition, the respondent has been convicted of having attempted, has been convicted.
See, that's another hardship again.
No, wait, what is
of having attempted to
16 what?
16 sub E.
You know how long to take for you to get a conviction?
Having attempted to kill, unlawfully kill the petitioner, or having committed an offence involving intentional infliction of, because you know that a person is presumed innocent or proved otherwise. So the fact that you came as a woman to say the man tried to kill you does not mean the world will believe until the person has been convicted.
That's another hardship. That's what I'm saying.
It's not the hardship, it's the law.
Because all through that period,
if you allow everybody to now say he tried to kill me, and we believe it,
CCTV evidence that he tried to kill me,
it will be used as evidence in court.
But you get what I'm saying? What I'm saying is that, like, before the way our system is set up, before you get that conviction, you would have been in that marriage for 3 years.
No, this one will not take 3 years.
Oh my goodness.
Okay, the way our jurisprudence is,
I promise you, you'll be in that marriage for at least 1 year. Before that.
No, but even if you are to be in the marriage for 1 year,
wait somewhere else now.
Look at it. Even if you are to be in the marriage for 1 year, you understand? That's why there is room for separation. There's nothing limiting you from separating.
You can even file a suit.
So if they bring knife
for separation, directive for separation,
pending when, yes. It's just that it will actually be unreasonable for you, as much as you are sensing hardship. You understand? It's unreasonable for you, even with the way you used to think. Yeah, it's unreasonable for you to just say, you got married though, in a marriage that you expected to last forever, naturally. Then just within 1 year, you just want it to just end immediately. Like you get.
But do we agree that you cannot leave a marriage now under the Act in 72 hours?
We agree in Nigeria.
It's not. Where are you before you?
That's what I'm saying.
Jay, do you agree with me
yes,
on
no,
that?
that's what
So
you
doesn't that defeat the entire purpose of marriage being a contract? We are very emotional about this marriage thing.
There are different types of
say that-
contracts.
we
Hello,
say
ma.
that-
Do you know that there are irrevocable contracts?
Marriage is not one of them.
It is a suggested.
It's a suggested irrevocable contract.
Emotions.
No, it's not entirely irrevocable, but by the everything cannot be exactly the way you want it. Because we took our laws from England and they had the perspective.
That the English people
They
have
moved on. Yes, they have a perspective of growth. The way the English environment has grown, Nigeria has not grown to that level.
Why?
Yes, we haven't.
Why?
The English system is entirely different currently. The powers of a woman in the English system is different from the powers of a woman in Nigeria now. So that is even a different scope entirely. Do you understand? But looking at the intention, they now check
What is the
why did these
intention?
people try to get married in the first place. There's
So it should last longer.
marriage under the act. That's why rather than a woman feeling we should get married under the act, we should get married under the act so that I'll get properties or I'll get this.
I don't even know where they got that.
That's the thing. That's the purpose of the review of this law. So that people will now know that it's not about what you are thinking. Calculate the fact that the day you enter under the marriage under the act, you cannot leave immediately.
What's hardship?
It does not work hardship, it works process.
The thing is that what
It was process, but for
Yeah,
better life,
process.
how can you say somebody that you wanted to spend the rest of your life with?
You now want to
And
live
then-
72 hours.
Yeah, and you cannot separate.
Didn't you watch the person? Didn't you date the person? All the while people were going to pay dowry, you did not know that the person can use life to chase you.
Yeah.
The day after the marriage, I mean, there's something you did not say since you now said after the
I
marriage.
was
that
very
conversation.
I was in
The
court
thing is
and
that-
this woman filed for divorce and the judge was not telling her that in this my court, I don't used to grant divorce. That in this my court, it will take up to 3 years. She was telling the woman face to face that in this my court, we do what we call reconciliation.
Yes.
That's divorce where they find.
That is why the
That
contract
what
is
you know.
perpetual.
The law we will
That is why
the
the-
judge can be a mediator.
Yes, that's why the contract is perpetual.
But
It's suggestively perpetual.
But the thing is that
Suggestively.
before you say you want to marry this person, like what are your reasons?
Love.
Because the way you are talking now, you have a 72-hour intention to marry.
What do you mean?
That's what I'm saying.
Not
Because
just being.
you should naturally
No,
know.
you are not realistic. 72 hours real.
For you to even think of
Because for you to have married somebody that you had hoped to spend the rest of your life with, like if I'm to even leave you, I will stay without a woman. I will stay for like 1 year at least.
Yes.
Upon separation,
You know,
yes.
it's not that long, right?
No, I'm just saying at least
At
1
least.
year that this thing I got myself into. Having waited
Why
so many
did I?
years.
Yeah.
Why did
So
I?
during that period, you'll be single and celibate.
Yes.
It's not a big deal, man. So this section really got on us. So that was section 35 sub A. Now section 35 sub B. They say a decree of nullity of marriage shall not be made upon the application. So the A has said that if a petitioner says that the respondent is unable to consummate the marriage, and that petitioner knew before the marriage that the respondent was unable to consummate, he cannot raise nullity of marriage, but he can raise dissolution of marriage. You know, nullity is that it's void ab initio. Dissolution is that it was correct, the marriage was properly entered into, but now I want to leave. Then the sub B says that you cannot raise a petition for nullity of a marriage upon the petition of a party suffering from the disability of the disease on the ground that the marriage is voidable by virtue of section 5 sub 1 B or C of this act. So you that has the disease, section 5 talks about voidable marriages. Sub 1B talks about the person that is of unsound mind, mental defect, or subject to insanity or epilepsy. So if it is you that has the disease,
C talks about venerable disease.
or venerable disease, yes. So if it's you that has the disease,
You
cannot be the one that will now petition that the marriage is a null and void, where you are the problem that made it null and void. It is the other person that does not have the problem that should be able to now petition. So this now is checking who should petition.
is that what is confusion?
Yes.
Yes, what's the, but if you understand something different, let us know.
You should read from the top, basically. So that's what I was also trying to point out in the A part. But
Do you get something different?
Maybe I'm
Say what you get so that we'll just discuss.
seeing it from the point that you cannot say that the marriage was void or is void as a result of what is, should I say, a particular challenge that comes in between after the dissolution of the marriage, like disease and all that. You cannot put the marriage in a state of being void or voidable as a result of disease or in any inability that comes thereafter.
No, you can. There is nothing that says thereafter.
If it happens within the marriage, then it's voidable.
That's not what this section is saying.
But can I get if I just get the word that reflects thereafter, I'll pick that. I don't see a word that reflects thereafter. It says of this decree of nullity of marriage shall not be made upon the petition of a party suffering from the disability of the disease
That is him that
on the
Yes,
ground
it
that
cannot
the
be
marriage is voidable by virtue of. So the section we now went to relates to those diseases as grounds for a marriage being voidable. But it says you that has the disease, you cannot now be the one that will now petition for nullity.
is the other person now that can now petition that, oh, okay, I used to think that epilepsy is like this, so but however, when I got into it, I don't think you understand that, okay, I cannot cope. So the marriage is null.
No.
Or the person got into the marriage unknown to the person that this person is epileptic. Maybe they've been together all this while, but that performance hasn't come. Then the person just got into the marriage 1 week performance. Once there's that performance, then you can now.
I have an input. What if the person, for instance, now who is on venereal disease, or for instance, if out of sympathy, like, and based on the fact that the other person is suffering, maybe they are not having sex, there are some limitations, and he wants to like fight for divorce because of the other person, empathy to like one is like.
He can file for
divorce. That is the solution of marriage.
But he cannot file for the divorce. But he cannot file
that the marriage
was not void.
I have an input. What if the person, for instance, now who is on venereal disease, or for instance, if out of sympathy, like, and based on the fact that the other person is suffering, maybe they are not having sex, there are some limitations, and he wants to like fight for divorce because of the other person, empathy to like one dislike.
He can file for divorce.
That is the solution of marriage.
But he cannot file.
The venereal disease.
Can file for the divorce, but he cannot file
that the marriage
was null and void.
Okay.
He cannot file that the marriage is a nullity ab initio, but he can file for dissolution. And it is not even totally in his place even for dissolution, because it is the person that has suffered the hardship that should petition, not you that is not suffering any hardship. Because for the person not to petition, that means the person is ready to manage.
You have not married the person to start with.
There is no empathy.
The person you are sympathizing with is ready to manage with you.
That's it.
In fact, we have seen circumstances where you file for divorce. The other person now says, I don't want to divorce.
Yes.
The court will say, you people must continue in the marriage, because if you must divorce, even the other person too should be tired of the process. So by the time the person brings in some defenses to show
like
that this thing I say is not correct, I don't even see the reason why we should divorce. The court will say, go back again.
Like the adulterer now saying, no, I want us to divorce because I've been cheating. But the other person is not like, no, I don't mind you.
I don't mind you cheating. I've not even caught any cheating.
I don't know what he's talking about.
That one is it. So I even think that these are part of the safeguards of this law. Do you understand? You should ordinarily check your intentions and get married.
Yeah.
So if you checked your intentions and you got married, then now for some reason you just want to go and marry another person.
Say this one is final.
You don't want this one, but because the law now limits you, you now want to just divorce this one.
You think this is a joke?
It's not a joke. So the law is saying that you can't come here, sign in, and say because you want something else, you sign out. In fact, if you are caught in adultery, you will pay damages because you have signed in.
After you pay that damages, you will remain in this marriage.
Yeah. So do you know you can be filed. You pay damages for adultery, not to dissolve the marriage. In fact, the wife can take up criminal actions against you, petitioner. Crime against the state for adultery. You will be prosecuted, convicted, sentenced accordingly, then you come back to the marriage.
Yes.
It's just whether you will be in the same state of mind. So, sub C, section 35, sub C. A decree of nullity of marriage shall not be made upon the petition of the wife on the ground that the marriage is voidable by section 5 sub 1d.
Okay.
And section 5 sub 1d is that the wife is pregnant by a person other than her husband.
Interesting. I love this.
So you now, you are pregnant as a woman for another man. You cannot file for divorce.
It's the man that ought to not
It's
file.
the man that should file to say that this marriage is void because at the time I got married to her, she was already pregnant for another man.
Interesting.
No, but there's nothing interesting there. The man will always file. So don't.
You know,
There are so many people that are married that they'll find out that
You know, it's
No, listen. What I'm looking at is that she's looking at it that we finally got the man.
No, not necessarily.
That's her point. You understand? But my point is that if it happens to me, ordinarily, I will fine.
That's the whole point. That's not what happens realistically. Because sometimes they will marry. After they now get married, they'll be married for like 5 months, but you're like 7 months pregnant. How?
No, it's not that one self. It's sometimes it's after 14 years.
It's possible. And
You will now realize that the child, the father will not, like there's a case we had. You remember that we went to serve a letter. And the guy said the child in that house is my child. The man did not know at that time. Which means that pregnancy was there before the marriage.
And looking at the step that lady took, it's obvious
she was aware. So it's the man that cannot. But if you now look at the span of their marriage, probably they even had another child that's now their child. He might just say, okay, if this is not my child, give the child to the.
But you also know that legally,
No, but it depends on
child that is born in a marriage belongs to the parties of that marriage.
Legitimately. However, it is subject. That is a presumption.
That is a presumption. It's not the fact. It's capable of being vitiated.
Yes, once the superior information comes, it vitiates that.
It vitiates that one. But then
the child is not your own.
No, if there is a DNA that says child is not your own, the court should give it the child by force.
Yes, I'm married to the mother.
No, you are married to the mother. The father is alive.
The father is alive. If it were you, will you accept it?
I have the father.
So please limit yourself.
Even if you as the woman.
What would the court consider the best interest of the child? Let's even look at
the best interest of the child is for the child to stay with his father.
I've grown up with this man as my father. Why do I want another father?
Let me give you a personal example. In our family, not my father, but our family. A man had a child. Yes. And the child was with another family. The mother tried to bring the child. He rejected the child. So the child has grown up with another family till he was to get.
Mention their name.
Yes, the other name. He was to get married. So then he was to get married that the man of God told him that you are not staying with your father.
He didn't know.
He didn't know. So he began to go and question the mom. The mom now went to show him that yes, this is supposed to be your father. I don't know if they eventually did DNA test. He now changed his name and automatically became the first child of that other person.
Accepted him now.
Is it accepted? This is your child now.
This is your child now.
So now we are going spiritual, boys.
It's not spiritual.
He's
the boy. That's why I say the best interest of the child
is to be with his own father.
So now that he's an adult, he can make that independent decision now.
No, is there an independent decision as to being a biological father or otherwise?
The child is like